Hi friends, this is CMA Deepika.bhugra Prasad, insolvency professional. The Code IBC 2016 has evolved over the past 10 years in all its dimensions. One of its aspects is about the distribution of the realization from the resolution applicant amongst all its creditors. So friends, I welcome you to Insolvency Insights, a snippet series curated by me to delve into important judicial pronouncements under the Code IBC 2016 and to navigate through the intricacies of its proceedings. So friends, let us just discuss today one such case. So this is the case of Indian Bank and others versus State Bank of India and others, which was decided on the 8th of April 2026 by the Honorable NCLAD. So what were the issues before the Honorable Court? Whether the monitoring committee can alter the distribution mechanism approved by the CoC and whether payment to the dissenting financial creditor must be made in accordance with its security interest as per the CoC-approved mechanism. Whether the distribution mechanism approved by the CoC in its commercial wisdom and subsequently by the adjudicating authority is valid, lawful, and binding on all stakeholders, including the monitoring committee, and clarity on the distribution of the resolution plan proceeds to dissenting secured financial creditors in terms of Section 30, subsection 2b, Section 30, subsection 4, and Section 53(1) of the IBC Code. So let us see the factual background of this case. Indian Bank, being one of the financial creditors, initiated proceedings under Section 7 of the IBC 2016 against the corporate debtor OCL Iron and Steel Limited. And pursuant to an order dated 20th of September 2021, the CD was admitted into CIRP. During 18th CoC meeting on 23rd of September 2022, the CoC deliberated extensively on the distribution formula for the resolution amount. On 28th of September 2022, the CoC approved that if resolution proceeds are lower than the liquidation value, then distribution would be based on each secured creditor's share of the liquidation value. In the 19th CoC meeting on 30th of September 2022, the mechanism was reaffirmed, emphasizing distribution based on security interest share. All members, including appellants, unanimously agreed to appoint an evaluation advisor. The evaluation report dated 7th of October 2022 determined respondent number 1's, that is SBI's, liquidation value at rupees 64.56 crores. Now, in the 20th CoC meeting on 7th of October 2022, it was agreed that the dissenting creditors would be paid at least their minimum liquidation value. The resolution plan approved by NCLT on 20th of March 2023 incorporated this distribution mechanism. The plan states that dissenting creditors shall be paid in priority and in accordance with Sections 30, subsection 2b and Section 53 of IBC. The distribution was based solely on the security interest in the steel unit, excluding its auto division. The CoC's decisions were made after detailed deliberations and expert evaluation and are binding. The first monitoring committee meeting held on 27th of March 2023 and the second meeting held on 2nd of May 2023, wherein discussions took place regarding the distribution of resolution plan proceeds. In the third and fourth monitoring committee meetings held on 3rd of May 2023 and 4th of May 2023 respectively, the lack of consensus regarding distribution to dissenting financial creditors was recorded. The successful resolution applicant transferred an amount of rupees 35.20 crores on 15th of May 2023 to State Bank of India as a dissenting financial creditor. Aggrieved by the same, SBI, that was respondent number 1, thereafter filed an IA on 18th of May 2023 before the adjudicating authority, seeking to set aside the distribution decided in the fourth monitoring committee meeting. Adjudicating authority by the impugned common order dated 5th of February 2024 directed that distribution to State Bank of India, being the dissenting financial creditor, be made in accordance with Section 30, subsection 2b of the Code as computed by the evaluation advisor. Aggrieved by the impugned order, the present appeal was preferred by the appellant banks under Section 61 of the IBC 2016. Now, what were the analysis and the findings? It was categorically held that the commercial wisdom of the CoC regarding the manner of distribution, once exercised, cannot be changed subsequently, even by the CoC. It was held by the Honorable Court that the further statutory scheme contemplated by the IBC Code is that after approval of the resolution plan, the CoC itself is also bound by its finality and cannot be allowed to tinker with or modify the resolution plan, including the mechanism of distribution. It is true that the CoC with commercial wisdom can take a decision regarding different aspects of the plan, including manner of distribution, which is also statutory scheme under Section 30, subsection 4. But once the commercial wisdom has been exercised by approving the resolution plan in the meeting dated 5th of August 2021, the modification of the said distribution mechanism, which is impermissible, cannot be saved in the name of the commercial wisdom of the CoC. What are the roles and authority of the monitoring committee? The monitoring committee was tasked with supervising the implementation of the approved resolution plan, but lacked authority to alter distribution terms post-approval. The MC's fourth meeting on 4th of May 2023 arbitrarily decided to pay rupees 35.20 crores to respondent number 1 instead of rupees 64.56 crores. The chairperson and legal counsel of MC recorded that modifying the distribution mechanism would be contrary to law. The decision to alter the payout was beyond the monitoring committee's jurisdiction and violated the finality of the approved resolution plan. The tribunal referenced a similar case of Bank of Baroda versus IDBI Bank 2025, where it was held that post-approval modifications to distribution are not permissible. The MC cannot revisit or modify the commercial wisdom exercised by the CoC during the plan approval. Now, what are the legal principles governing distribution and finality? The case emphasizes that once a resolution plan is approved by the CoC and sanctioned by the NCLT, its terms are final and binding, and subsequent modifications are impermissible. The approved plan, including distribution mechanism based on the liquidation value, is binding on all the stakeholders. The decision in Bank of Baroda versus IDBI Bank in 2025 confirms that the CoC's commercial wisdom cannot be altered after approval. The distribution to respondent number 1 at rupees 64.56 crores is in accordance with sections 30, subsection 2b and 53 and the independent evaluation. The Honorable Court enforced the distribution mechanism approved by the CoC, not an arbitrary or extraneous decision. The tribunals dismissed the appeal, affirming that the order aligns with the legal principles and statutory provisions. So, friends, we conclude that the court affirms that the distribution mechanism approved by the CoC and the adjudicating authority is lawful and binding and in accordance with law. The monitoring committee cannot alter the approved distribution mechanism. The payment to SBI based on liquidation value complies with Section 30, subsection 2b and Section 53(1) of the IBC. The appeal by the assenting creditors is dismissed and the impugned order is upheld. So, friends, we see that the jurisprudence has been evolving based on the rules and regulations and the sections of the code and are sacrosanct. So, friends, I hope and believe that you find this both interesting as well as enlightening. So, for further insights into such judicial pronouncements under the Code IBC 2016, please like this video and subscribe to my YouTube channel. So, friends, thank you for being with me today. So, this is Deepika B. Prasad signing off for now, and we'll catch up again. Thank you.